The Uniform Civil Code is back in focus. The politics around it, of course, are one thing. But what about the legal debate? The Uniform Civil Code, of course, is something that has hit the headlines almost in every election season. But could something be different this time? I'm Barkha Dutt, you're with the Mojo story. On this program today, we'll be looking at whether the Modi government will move to actually make the Uniform Civil Code a reality. Now, there are kinds and kinds of uniform civil codes. While the opposition, of course, has typically opposed the Uniform Civil Code, conflating it with Hindutva politics, there are also other progressive groups that have spoken of what they call a family law, a modern family law that applies across communities and across genders. On this program today, we will be looking at the legality, the legal debate around the Uniform Civil Code. Let's bring up on the program now one of India's best and most respected legal scholars who's done some very interesting work and research on this subject, Faizan Mustafa. It's always a pleasure, sir. Let me start by actually asking you. There is a lot of confusion about what is personal law. Now, India is a secular country. The word secular is in our preamble, although it was added in the 1970s. But yet there is space for personal law. Some might say, why does personal law exist? What is personal law? And if a personal law is regarded as a divine law, then how can mere humans move to legislate it? This is sometimes a debate you hear from religious leaders. You have written that the Muslim personal law, for instance, is not law under Article 13 of the Constitution. So let's start with that very fundamental question.
Yeah, thank you, Barkha, for having me. Now, first of all, this whole question of personal law and religion, I think, must be clarified. Many people are taking personal law and Sharia as one and same. My position has been that Sharia or religion deals with relationship of humanity with God, and therefore believe in oneness of God or books of God or angels of God of day of judgment. These are the core religious ideas. Now, when we come to Sharia, then it is the revelation or Wahi which will be the main source. On the contrary, the correct word for law in Arabic is fiqh. Now, fiqh is law which is based on speculative reasoning. Now, law governs the relationship between human beings. So, human beings will marry and divorce and die, and their property would be inherited and they would make will. I'm of the opinion that in His wisdom, Allah Himself decided not to give us law as a finished product. And that is why in Quran, out of some 7,000 verses, you have just about 200 which deal with law. And therefore, the human beings have been given this right and power to discover their law. Of course, they will look at Quran and the Sunnah and the other sources. And if you look at other sources of Islamic law other than Quran and Sunnah, which are what the Prophet said and what the Prophet did, they are all human, urf, customs, juristic preference, or ijma, consensus amongst the jurist, or the public interest. All these are human. So I would say that while the religion got completed with the Prophet, it is after some 200, 300 years after Prophet that the Muslim jurist developed fiqh, or what you call personal law. So it's a jurist given law. It is just like Roman law. Roman law was also jurist given. So Muslim personal law for me is a private enterprise. It has not been enacted by any state. It has not been entirely given by law, by God. And you would see that if you look at Mughals or the Delhi Sultanate, they did not interfere with the personal law of Hindus. And then when the British came in, then Warren Hastings issued Regulation 2 in 1772, and he uses very interesting word for Muslim personal law. He says if the parties are Muslims, law of the Quran would be there. And if parties are Hindus, then the Dharm Shastras will govern them. This is how the
So,
Muslim
so, so,
personal
so,
law, Hindu law originated. Yeah.
So basically, you're arguing that that law, there is space in religion itself, in Islam itself, for in this case, for human beings to step in and keep building and evolving law as it is needed to govern different communities. Now, let's start with a very interesting question. When the state of Uttarakhand took an initiative on the Uniform Civil Code, you welcomed it, right? Why did you welcome it?
I welcomed it because, if I have to blame somebody for the delay in the enactment of Uniform Civil Code, it won't be judiciary. In fact, judiciary was unnecessarily too active, and at times their observations were not right. It is the parliament which has made some laws, some reforms in personal law. So you had the Sharia Act, you had the Dissolution of Muslim Marriage Act, you have the 1986 Act. Recently, you saw the triple divorce law. So there has been legislative activity in terms of reforms. In fact, to believe that the entire Muslim personal law is unreformed and uncodified is wrong. Part of it is codified and a statutory law, and part of it is uncodified. It is the executive or the government which has not done any endeavor whatsoever. I can recall only Mrs. Gandhi in 1971 addressing the All India Congress Committee in Ahmedabad, urging his party and the people of the country to think of Uniform Civil Code. But thereafter, the governments have not really taken any substantive step. There is no draft available to us to debate. And therefore, when Uttarakhand Chief Minister on the last day of the campaign, he said that if we are voted to power, we would set up a committee of experts. I welcomed it. Personally, Barkha, I feel that law reform should not be seen in the context of electoral politics. I have this problem even today. I had this problem with number of other states. But post that constitution of committee, if you look at the composition, I have said that the composition is uninspiring. You have bureaucrats there, you have one retired high court judge, and you don't have any personal law expert of different communities. So such a committee is useless. It is not going to inspire anybody.
Yeah. So what I'm hearing you, let me correct me if I don't understand you accurately, but here's what I understand. You are saying that the Uniform Civil Code has been treated as a bogey. No one has ever actually placed in the public domain a draft that can be discussed. You are saying that the change cannot come top down from the judiciary, from the Supreme Court, that the change should come through the legislative assemblies, maybe, if at all, and that those who are tasked to discuss this must reflect the very pluralism that they're supposed to preserve. And the most important point that you're making is that there is no contradiction between pluralism of religion and a uniform civil code. In other words, Article 25, that gives every Indian a fundamental right to profess and propagate your faith, is not at odds with a uniform civil code in principle.
No, Barkha, my position as a constitutional law teacher, it is a little difficult to understand and nuance. On the one hand, I don't see much merit in universal legalism. As someone who teaches diversity and diversity law, I see that legal pluralism is an equally good tradition. Therefore, I am not for one
Why do you
code.
say that?
So you can have multiple codes. Yeah, you can have
hold you there?
multiple. Yeah.
Can I hold you there? Because as a woman, as a feminist, my first rebuttal to you would be, why do you support legal pluralism? Aren't there some universal principles, for example, that should apply to the principles of gender justice? And the Muslims are not the only community that have had to battle this. We've had the Sabrimala debate, where the Supreme Court had to review its own verdict on allowing menstruating women inside the Lord Ayappa shrine. So here's my question: when you say you're not a fan of legal, a kind of one
Universal
dimension
legalism. Yeah.
universal legalism, how do you ensure a framework for gender equality then?
Yeah, that's right. That is the difficulty, that this whole idea of universality of human rights makes room for cultural relativism. Human rights themselves provide for cultural relativism. Now, while providing for cultural relativism, you cannot be discriminatory. Therefore, the gender justice aspect has to be taken care of. While I'm for legal pluralism, therefore, I'm saying you don't need one code. So you may have one code on marriage, one code on divorce, one code on inheritance. You can have multiple codes. And I have repeatedly argued in my articles that for me, uniformity in itself is not something very great. Unity is far more important. That's why when Ambedkar was saying that if any government provokes Muslims with the implementation of a uniform civil code when they are not yet ready for it, it would be a mad government. Now, what I would say that you should have a just code. And what is a just code for me, which is far more important than a uniform code? You may have multiple laws. If you have 5 codes, I don't mind them. But all 5 codes must be consistent with the constitutional ideal of gender justice and substantive equality. I would not accept the formal equality. You need to have substantive equality. So just code to me is far more important. In any case, right to equality, as Barkha, itself says that unlikes are not to be treated alike. Likes are to be treated alike. And therefore, the law within the class has to be same. But having said that, there is absolutely no to have laws which are discriminatory. And that's why rather than aiming to have a uniform civil code, we must ensure the discriminatory provisions of all laws, whether they are secular laws or religious laws. You have number of secular laws which are discriminatory.
So you are saying that rather than chase the concept of a uniform code, personal laws can be reformed in all communities to bring them to a level where they uphold the essential fundamental principles of equality. So you would rather go the route of modernizing and reforming personal law rather than having a single uniform code. Is that correct?
Yeah, that's right. Because even in criminal law, Barkha, you don't have a single law. The moment you have federalism and you have 3 lists, your constitution itself is permitting states to enact laws. Now, many people have asked, how come Uttarakhand go for uniform civil code? Personal law is there in the concurrent list, entry number 5. And therefore, both center and state can make laws. In fact, it is really surprising that or Uttarakhand, in election, they are promising a uniform civil code. Now, if you look at Article 44, it is saying state shall endeavor to have uniform civil code throughout the territory of India. How can Uttarakhand pass a law which will be applicable throughout the territory of India? So it was not a uniform civil code, but they were playing to the gallery. It was an electoral promise meant for a particular constituency, and then they may get some votes out of that. That's okay. But what I'm trying to say that it is possible to have multiple codes. Even in our criminal law, where you have Indian Penal Code, many states have made amendments. In Code of Criminal Procedure, in some states you will have anticipatory bail. In other states you will not have it. In Punjab, for instance, for blasphemy, there is no one even uniform criminal law. States already in federalism have a right to legislate on us the subjects which are given in the state list and which are given in the concurrent list. So federalism does not envisage a single law. You are in United States right now. Now each state has a different criminal law and each state has a different constitution. And that has not made America a weak nation. Initially, this whole uniform civil code debate was in the context of gender justice. Then it was hijacked, and cultural identity came in, and national integration came in, and then subsequently, when Nehru brought in Hindu Code Bill, then the Hindu conservatives, to install the Hindu Code Bill, they said first bring the uniform civil code.
Right. Now, I want to understand something from you. You said that reforming personal law is better than having a singular code. Won't that be a long process? We've been talking about, for example, reforms in the Hindu personal law since the 1950s. One of the criticisms that the BJP and its supporters make has been that the Muslim personal law has been too slow to modernize, and attempts to modernize it have been met with resistance. Take triple talaq, for instance. Many Muslim women were at the forefront of asking for that change, but when the clerics were asked for their opinion, they opposed that change. So when the religious leaders of a community oppose that reform, how can that personal law be reformed? How can that be then the way that the inequality in these laws is addressed?
Barkha, one factual error. Muslim law reform was ahead of Hindu law reform. If you look
Okay.
at dissolution of Muslim Marriage Act 1939, the Muslim women is getting a right to dissolve marriage if there is a cruelty, if the husband is absconding, and number of other things. Even if now, if husband has taken a second wife, if husband is impotent, number of things. Hindu women will get this right in 1955. Two, if you look at Shastric law as such and the Islamic law, because Islam as a religion came much later, under the influence of Roman law, it already had few things which were reformed. For instance, women as an independent owner of a property. This idea was not there in Hindu law. But in Islamic law, if you look at the Quranic heirs, who are the category 1 heirs, as many as 12 of them, 9 of them are women. And they can own property in their own right. Husband will not have any claim over their earnings or their properties. So Muslim law was ahead, and that's why there was greater need to reform the Hindu law. But how did we reform the law? 1941, we constituted an expert committee of Shastras and Hindu law and Sanskrit. From 1941 till 1955, this committee has been working. When initially Hindu Code Bill came in, out of 27 speakers in Lok Sabha, when Ambedkar as law minister piloted the bill, opposed it, including the Congress president, including the ministers, including the president of the republic, Rajendra Prasad, who said that I would refuse my assent. And then Nehru had to make compromises. What were the compromises? For instance, Hindu daughters were not given a share in the ancestral property. What were the compromises? I just tell you, the Guardianship and Guardians and Ward Act, which was a universal, uniform law applicable to all communities. When we came up with Hindu Adoption and Maintenance Act, it diluted it. Hindu Marriage Act was a dilution of Child Marriage Restraint Act. If you look at the Parsi marriage law, or if you look at the Special Marriage Law Act, which is a uniform civil code, a child marriage would be void. But under the Hindu Marriage Act, we made child marriage as deemed valid, and the penalties were also reduced. So there were a number of compromises which Nehru made, and then this process is long drawn. It was as late as 2005 that the UPA 1 government brought in an amendment and said that now Hindu daughters would also become the co-partner and will inherit in the property. So what I'm trying to say, that of course Muslim clergy is to be blamed that they did not really move at the pace at which they were supposed to move. But government also never tried to constitute any committee of experts which could have come up with some kind of a draft. So we are talking in the air. Nobody really knows what kind of uniform civil code we are going to have.
Let me ask you a last question. Would you advocate the Uniform Civil Code to be optional for states? Do you think the route through this change must come through states? Do you think, how should this conversation move forward so it's not just a bogeyman in our political debate?
I would say maybe this is an option, that rather than bringing a national law, we try it in some states. Not a bad idea. But more than that, I think we need to talk to the Muslim community and tell them that forget about a uniform civil code. Even the modern Hindu code bill has borrowed heavily from Islamic law. In the classical Shastric Hindu law, once a marriage, always a marriage. They are united blood to blood, flesh to flesh, bone to bone in this life and 7 lives hereafter. And therefore, there will be no divorce. Marriage is to be solemnized. That's why many people who take a second wife, they don't complete 7 steps, they will complete 5 steps, and they will have a second wife. And since there are no 2 valid marriages, they will never be punished for bigamy. So number of things in any uniform civil code would borrow from Islamic law. If Islamic law is based on equality and is based on justice, and Constitution of India is also based on equality and justice, then we have to probably talk to them and tell them that within their law, number one, there is a flexibility. For instance, polygamy. On the basis of Quran, we can say that Allah himself is saying better not have one, because you cannot do justice. Therefore, anyone who says that you should have more than one wife.
Yeah, no, I didn't mean to interrupt you, but isn't that a dangerous subjectivity that is being brought into to law? Because the thing about law is that there should be a certain certitude that if this happens, this is how you're punished. If this happens, and of course, ideas of that can change, as we have changed, for example, with homosexuality, we decriminalized it. Now we're debating same-sex marriage. But when you say that Quran mein hi iska jawab hai, not everyone may agree with you. Somebody may interpret the Quran differently, right? So my question, and my last question, I know I said that before, is how will you address the danger of subjectivity? When you advocate that the answer lies within faith itself, and to what would you say to your community, to the Muslim community today about this debate?
No, number one, I would say that Constitution and Islam are consistent. Constitution is also talking of equality. Islam is also talking of justice. Any law we are making, it should be within the framework of how we understand equality and justice today. There are reforms which are possible without anything. Polygamy is one such reform. Nobody can object to it. Similarly, child marriages.
Yeah.
Islam may permit, child marriages, but it is not saying that every child must be married. Therefore, if today we say that there will be this minimum age, it is not going to be violation of any Islamic rule. So what we should try to do, that we should move in a direction in which there would be least resistance, as we say, happiness of the greatest number, that we should try, minimum friction and greatest happiness. If to have uniform civil code right now, straight away we are going to end up with some controversy, then it is not a good option. We should try to develop consensus about the issues on which there is absolutely no dispute. For instance, if we say in law that all divorces would be by mutual consent, and convince the Muslim community that one of the type of divorce under Islamic law is divorce by mutual consent, they cannot oppose it because it is there. The government is not going against Islamic law, is not going to violate their freedom of religion. So pick up those elements of law about which there will be least resistance. I always say that law reform or uniform civil code should be made piecemeal, and therefore first try to reform the marriage law, then try to reform the divorce law, then go to the succession law or inheritance law, where there will be real problem, because we have already said that under freedom of religion, if something is in Quran, if you look at triple divorce or other judgment, the whole doctrine of essentiality, then the court will accept it as part of freedom of religion. So since those shares are fixed, it is not easy to reform them. So go slow, but in a systematic way, initiate the law reform, make laws consistent with Constitution. In modern democracy, no community or no religious denomination can insist to have a law which is not compatible and consistent with the constitutional mandate.
All right, we leave it there. It's been a fascinating learning talking to you, Faizan Saab, as always. Thank you so much, one of India's foremost constitutional law experts on the Uniform Civil Code debate. Thank you very much, sir. Take care.
We started Mojo right here in this basement. Just 4 people, 4. And now we're about to hit our first 1 million subscribers. So this is to say thank you to all of you for your support, for your respect, and for your encouragement. We've always gone to where the story is. During the pandemic, when television's big anchors were hunkered down in their studios or at their homes, we hit the road. We traveled from Delhi to Kerala, covering 30,000 kilometers in a small car, reporting from inside ICUs and inside slum tenements. Whether it's flash floods or war zones, we've always put our boots on the ground. In fact, we're just back from Punjab, tailing the Khalistani fugitive Amritpal Singh. And through all of this, we have always put you, the people, first. In an age of partisan polarized media where most journalists are either chamcha ya morcha, we believe the story is sacred and the truth of the story is what matters. And now as we get ready for the next step, we need your help. Become a Mojo member and get first access to all our big interviews. Get a chance to ask our newsmakers questions. Get a chance to write and report for us for both our website and our channels. And also, interact with me and my colleagues directly through AMA sessions. Literally, ask me anything. Click on the join now right next to the subscribe button, and yes, also subscribe if you haven't yet, and become a Mojo member for just 159 rupees a month. Hope to see lots of you in our community.
It's great to see you here. Thank you for watching our work. If you haven't subscribed yet, don't forget to click the bell icon and subscribe to Mojo Story and support independent, robust journalism.